The next section is public rights versus private rights. I just want to review that by saying that there's two different kinds of law. There's public rights and private rights. Public rights where there's a government interest, and private rights where there's no government interest. If one company, one small mom and pop shop is suing another because somebody slipped on their sidewalk or whatever, it's going to be all handled in private law. The government's not going to be involved in that. And there's also, with regard to the difference between public rights and private rights, I'm sure I don't need to review this for you because you're legislators and you're here and you know all this, but in private rights, everybody's protected by the Constitution. And in public rights, everything is statute-driven. And in public rights, when the government is involved, there's always a compelling state interest. There's always a protectable interest by the government, a pecuniary interest, a safety interest, an interest for the general welfare. But the general welfare has limitations according to the law. And on the far right-hand side there, private domestic relations has been left up to the states. The federal government, according to the Constitution, does not get involved. And here is a report from the Congressional Research Service out of Washington that says, under the U.S. Constitution, Congress has little direct authority to legislate in domestic relations and family law issues. That's the private matters. And that's clear the way our Minnesota statutes are written. In chapters 245 through 267, it's all about public welfare when the government is involved. In chapters 517 through 519, the revisor's office has labeled those chapters in the statute as private domestic relations. The problem is that in our state law right now, we've run into a problem between mixing public and private rights. We've got the public welfare in the 256 chapters, and we've got private domestic relations law, which started out in the 518 chapter. Now we've suddenly taken what was meant to be public law, which the Title 4D law, and we've embedded it into 518, so we've blurred those lines. We've crossed that bright line of separating public rights and private rights when it comes to family law become very different. In private rights, you get a judicial proceeding in front of a district court judge. In the 4D process, you only get an administrative hearing in front of a magistrate. And by the way, the 4D magistrates in the administrative process are all paid for by the pool of money that is developed through the child support collections money that's put through the system. We'll get to that more later. In the judicial proceeding, the judge can rely on his equitable powers. In the public rights in the 4D system, in the administrative process, the magistrate has no authority to rule on their equitable powers. Everything is statutory only. No constitutional issues can be heard in that court. They can only be heard in the judicial proceedings. And what's most disheartening for many people that end up in the administrative process is according to the expedited rules in the state of Minnesota, hearsay is allowed. So there's a lot of families that are impacted in incredible ways based on hearsay, that's where this sense of unfairness comes into play.